That's for that though.
Oh.
Hold on.
Hey, that looks good. What'd you do? Okay, is it up now? There we go. All right, folks. I think we're ready to get started, and hopefully this will work. Thanks again for your patience. Isn't technology wonderful? Okay, let me
Well, I'll cancel that ticket.
let me get my act together here. Nothing like waiting till the last second with this new system here to get things working. Okay. Welcome to this morning's webinar. I'm George from the Office of Open Records. This morning's webinar, we're going to be talking about right to know law and payment issues, which I always find to be a very interesting topic. A couple things to just go over here before we get started. First is that if you've ever participated in one of these webinars before, you'll know that it's essentially a PowerPoint presentation with me talking in the background. Couple things, if you have a question, feel free to type it in the chat feature, which we finally got up on the screen. And I'll do my best to answer your questions as we're going through. Try to keep your questions on point. We're talking about the right to know law and payment issues. So the more you're on topic, the better. Also, the shorter your questions are, the better, because quite frankly, it's just awkward for me to sit here and read several paragraphs sometimes that people type in while everyone else is waiting patiently. If it looks like you've got an unusual situation or something unique to your agency or whatever, we'll do one of two things. We'll come back to it at the end of the presentation, or we'll take the conversation offline. Right now on the screen, there is contact information for the office. If you phone in or send us an email, it goes to our administrative staff. They're well-versed in the right to know law, and they can usually help you out. If you do manage to stump them, we'll escalate your questions to one of the senior staff. They usually get back to you within 24 hours and pretty responsive with that. This session is being recorded. And usually what happens is it gets posted to our YouTube channel, and then a link is made to the website. So within a couple days, the chances are pretty good that you'll be able to come back to this recording and listen to it, watch it on the website. Same way with the PowerPoint presentation. If you go to the website under the training tab and scroll down, you're going to find all of the PowerPoints that we use for these presentations. They're public records as far as we're concerned, so feel free to download them and use them, for your own reference. Maybe you have some colleagues who couldn't make it this morning and you think it would be helpful for them. Maybe you're conducting some localized training and it would be, of use to you to have this information available. Feel free, have at it. And like I said, if you have any questions, reach out to our office. Okay. I think that takes care of all the preliminaries, and I'm kind of settled in here. So let's jump into the presentation. Okay. First thing you need to know first thing I need to know is, did the screen advance? Yes. Okay. It's a little slow, but it's working. Within the right to know law, in section 1307, it makes reference to the Office of Open Records being able to establish a fee schedule. You'll also find that on our website, the fee schedule itself. Okay, established by the Office of Open Records, posted on the website. It's reviewed every 2 years. I think that might be coming up soon. Usually what happens is we reach out on social media, let everybody know that this is coming up. If you have any comments, any concerns about the fee schedule, reach out to our office. And I'm proud to say that we have made changes to the fee schedule as a result of concerns both by requesters and agencies. We've changed the costs, we've changed how costs are calculated sometimes, and occasionally the courts will weigh in. If there is an appeal related to how fees are instituted, the courts may say, no, we believe that this is the intent of the right to know law, and this is how the fee should be applied. So take a look at that. And you can see down there at the bottom, read the footnotes, okay? If you look at the fee schedule, you're going to find some basic points, but then you're going to find all these little footnote citations down at the bottom. That will shed light a lot on how the fee schedule is applied in unique situations. So get familiar with those footnotes, and it might help misunderstandings when it comes to how fees are applied. But basically, the agency, when making copies, hard copies, they can charge up to 25 cents a page, single-sided black and white, 8.5 by 11 or 8.5 by 14. Now, there is one of those changes that occurred a couple years back, is that if it's a really big response and it's all hard copy, once you reach 1,000 pages, the maximum you can charge per page is 20 cents. And you're thinking, okay, well, you know, who's going to submit a request that's going to result in 1,000 pages? It happens. For instance, like with PennDOT and some of the right-of-way projects that they have, environmental groups will come in and submit requests with the expectation that they're going to get, you know, several thousand pages of reports, analyses, and so forth. So this 20 cents a page thing is real. It does apply. But take a look at those footnotes, and that will help explain sometimes what some of these fee charges, how they're applied. Okay, the agencies are also allowed to charge what are called pass-through costs, and these are, you know, actual costs that can be documented. And I'll just give you a couple examples here. Postage is a good one. Let's say that the scenario is someone submits a right to know request for hard copy records. The agency prints them out, you know, they've charged their 25 cents a page, but then the requester has indicated that they want the response mailed to them. Well, the agency, let's say they have a postage meter, like most do, they can take all those records, put them on the postage meter. Let's say it's going to cost $3.15 to mail them out. Well, you can add that $3.15 as an actual or pass-through cost. Let's say that the agency, another example here, someone submits a request for a copy of a blueprint. It's determined that the blueprint is a public record, and the agency does not have a large-scale copier. Okay, they have no way to actually make a copy of the blueprint. So they would run down to Staples or Kinko's, maybe the local architectural firm, and they're going to charge $10 to make that large-scale copy. Well, then the agency can take that documented cost and add it to the invoice that they would then forward to the requester in request for payment. Okay, that is an actual cost. Okay, copies of analog recordings, you know what? I'm just going to skip over that because I'm not aware of too many agencies that use cassette tapes anymore. Everyone has kind of evolved to using digital recordings. And then the final one that we refer to is flash drives. And okay, Walt, can a requester provide their own flash drive, blank CD, or can an agency demand the requester use one that the agency purchased? Walt, you are one slide ahead of me, okay? If the agency wants to, let's say they have their supply of flash drives, okay? They can then charge the requester for the cost of that flash drive. But the issue here is that that becomes cumbersome because then the agency, you know, let's say it's all digital media. Well, under normal circumstances, you wouldn't charge for electronic records. But if the files are so large that you can't email them, let's say that there's like a security limitation on your internet account, and you have to use a flash drive, then the agency ends up having to, number one, have a supply of flash drives, number two, having to charge for the flash drives to the requester, and then, you know, that can actually result in more time and effort than it's really worth. So what a lot of agencies are doing these days is, okay, I'm waiting for the screen to advance. Here we go. What we consider to be a best practice. And what they're doing, number one, for security concerns, number two, just because it's easier for everybody. The security concern is if someone comes in with a flash drive for a large amount of electronic records, usually the IT staff goes crazy saying, well, what if there's a virus on that flash drive? You're going to infect our entire network. So what agencies are doing is saying, look, you can come in with a flash drive, but it has to be sealed. It has to be unopened. And then what the agency is doing is they're taking the responsive files, loading them onto a laptop computer, and then disconnecting the laptop from the network prior to the flash drive being hooked up to the laptop. So that, let's say there would be a chance of, malware or whatever on the flash drive, the malware software on the laptop, the virusware on the laptop picks it up without it ever going to the network. Usually, because it's been sealed, it's brand new, unused, you're not going to find any virus on it. So you plug it into the laptop, everything's fine, transfer the files over to the flash drive. The requester then leaves with the flash drive and the files that they wanted, and then you can hook the laptop back up to the network if that's, how you normally operate. Okay, but you see how this works. Number one, the chances of a virus infection or malware infection is greatly diminished because of the process that you've gone to. Number two, now the agency doesn't need to maintain a supply of flash drives. And number three, the agency doesn't need to go through the exercise of charging the requester for the flash drive. Now, if you are doing that, if you're using your own flash drives and sending them out, that would be a pass-through cost because you can document the cost of the flash drive. But using this easier method, we think it works. I mean, that's what we do here in those instances, but it was actually brought to our attention by a number of municipalities that started doing this. And we took a look at it and said, this makes a lot of sense. So there's nothing in the law that says you have to do this. This is simply a practice that was brought to our attention that we think is a good idea. Maybe you want to consider it for your own use if you're in a situation where you have to provide a really large number of files to a requester in response to a request. Okay, right on cue there, Walt. Let's move on. Okay, what are some things that you can't charge for under the right to know law? Well, obviously, employee labor, whether it be an hourly cost or a fixed fee. I haven't been surfing agency websites lately. That's something the admin staff does. But every so often, it will be brought to our attention that on an agency website, they assess a fee for a right to know response. And it's based on labor charges. And it's very specific under the law that an agency cannot charge for their labor. So you need to be very careful about that. There has been legislation proposed in the past that allowed charging for labor in limited circumstances. Usually it's when when you're talking about what's called a commercial request, where the response, the records are going to be used for resale and for running a business of some sort. But those proposals have never gained sufficient traction in the legislature to actually become law. And I'm not aware of anything currently pending in the legislature. It's been pretty quiet here lately. So the bottom line is you cannot charge for labor. You cannot charge for any sort of legal review, whether it be your in-house solicitor or the solicitor that you have on retainer or any sort of outside counsel. Those labor fees are simply costs that are considered the cost of doing business in state and local government. You can't assess any sort of right to know law processing fee. And again, I'm not exactly sure what that means, but we see that periodically on websites for agencies. And when we do see that, we reach out to them and say, hey, you know, this is inconsistent with the law. And if someone were to file an appeal, you would lose and possibly be subject to sanctions. Same way with redaction fees. It's been a couple of years now, but I recall looking at an agency website where they said, number one, right to know response is going to cost you $10. And if we have to redact anything, it's going to be an additional $20. Okay. No, you can't do that. You cannot charge a redaction fee under the right to know law. Now, there may be limited instances where, as the result of doing a redaction, you can assess a fee, but not a standard redaction fee per se. Scanning fees. This has not happened in a couple of years, but we used to get calls probably once a month from an agency saying, look, I have to scan these records in to send them out electronically to the requester. I'm going through the same exercise with scanning that I am with making a copy. And it's the same degree of wear and tear on our copier. Why can't I charge for scanning? Well, the big thing is, number one, you cannot charge for electronic records. And what you're doing when you scan is creating electronic records. But the bigger issue, number two, is that there's a very good chance that you don't have to scan in the first place. And I'll be talking about that later on in the presentation. Okay, there is a misunderstanding that if someone requests records be sent to them electronically and you don't have them electronically, that you have to scan them in. You know, I'm kind of revealing my secret here, but and it's not really a secret, but the big thing is that you probably don't have to scan them in the first place. Okay, you can't charge for electricity. And you're thinking, okay, what's he talking about? Well, believe it or not, twice now, we've been approached by agencies, can we charge for the electricity? My first question is, you know, how are you going to calculate that? But bottom line is no, you cannot charge for electricity. You cannot charge for electronic records. Yeah, I already said this, but that's, you know, a pretty basic tenet of the fee schedule for the right to know law. So that means emails, Word documents, Excel spreadsheets, database files, okay? If they're in electronic medium and you have them in your possession and you've determined that these are public records, then when you transmit them to the requester, you cannot charge for the records because they're in electronic medium. What it comes down to is that you can charge for hard copy, and you're basically charging them for the paper and the copier toner. Okay, if you look at it that way, if I'm generating paper, if I'm using copier toner, that's what I can charge for. Everything else, it's either an actual cost that I can document, or it's an electronic record which I cannot charge for. And then if there is a dispute over what the agency is charging for, the requester can file an appeal, and it's based on a dispute over the fees. If you would go to the OR website and go to the final determinations database and just do a search on the word fees, several dozen appeal decisions will come up where you can see how the Office of Open Records, and in some cases how the courts, ruled on these disputes over fees. And that's what led to all of those footnotes on the fee schedule that I was referring to, because you get down into the weeds and it's like, okay, in this specific case, yes, you can assess a fee. Or if these are the circumstances, you cannot charge a fee for this specific scenario. Okay, so that's why, again, why those footnotes are important. Okay, this is kind of what I was talking about with the difference between electronic records and hard copy and the whole scanning scenario. You know, someone calls up and say, why can't I charge for scanning? You know, and I would ask them, well, tell me why you're scanning in the first place, because chances are you don't have to. If you go to section 701 of the Right to Know law, and I'll paraphrase here, but basically what it says is that the record shall be provided in the medium in which it exists. Let me translate that into English. It's hard copy versus electronic. That's the medium. You have records in hard copy medium, you have records in electronic medium. If someone submits a right to know request, let's say it's for building permits, the approved permits, okay? And the agency only has those in hard copy, but the requester wants them electronically. And why would they want to do that? Well, number one, it's easy because it's just a matter of sending them via email. Number two, it's free because you can't charge for electronic records. But the agency only has them in hard copy. Well, based on this language in section 701, you only have to send them in hard copy. Okay, you do not have to send them in electronic medium because that would be converting them, and you do not have to do that. Okay, now if you do have them in electronic medium, well, then you have to send them because that's how they were requested. So you see how that works. If you do not already have them in electronic medium, you do not have to convert them to electronic, just because that's how the requester is asking for them. Your response would basically be, you know, we have these records, but they're in hard copy. We're more than happy to make hard copies for you, but then we're going to charge up to 25 cents a page. So your request, you give them the estimate. It's going to be, you know, $30 or whatever. Then the person would have to decide, am I still going to go through with this request and pay the $30, or am I going to withdraw it? Or, you know, if they think the agency is pulling a fast one on them, they can file an appeal. Like I said, you can file an appeal based on a dispute over fees if that's, you know, what you're inclined to do. Okay, let's talk about medium versus format, because this is a kind of an interesting one. It's an evolving area of the right to know law. Okay, medium is hard copy versus electronic. Format would be, for instance, the software platform that's used to create the image, the record. Okay, and here I use Excel versus PDF. Now, originally, it used to be that, you know, agencies would be very paranoid about giving out an Excel spreadsheet because, my gosh, you can manipulate that and misrepresent what's on the spreadsheet. And then the requester can say, well, this is what the agency gave me, when in fact it was something different. So they were in the practice, usually, of converting the Excel spreadsheet over to PDF because you can't manipulate a PDF spreadsheet. Well, someone said, hey, I asked for Excel, not PDF, and they ended up filing an appeal, and it went to the courts. This is going back 10 years ago. The court said, look, you know, under the right to know law, you have to provide a copy, and PDF is a copy of the original, so that's acceptable. Now, a couple of years back, there was a new appeal filed. It went to the courts, and the courts, they kind of split some hairs here, but they said, look, if the person asked specifically for the Excel spreadsheet, then that's what you need to give. And if by chance they would manipulate the Excel spreadsheet because you can see the formulas behind the cells, et cetera, then that's an issue outside of the right to know law. Okay, that's, you know, then the agency could potentially take the person to court. What's interesting is that despite all these fears, it has never happened. Okay, no one has ever taken an Excel spreadsheet provided by an agency in response to a right to know request and misrepresented it in any way, you know, altered the spreadsheet. It's never, to our knowledge, it's never happened. It's never made it to a court. Okay, so the bottom line is, nowadays, if someone requests Excel, you must give them the Excel spreadsheet. If someone doesn't use the term Excel, then, or however, you know, the actual software platform, then the agency can give them a PDF, and that is acceptable. Okay, if they don't specifically ask for the format used to create the spreadsheet in the first place. And then occasionally you run across proprietary formats. This is usually with police departments. Sometimes it's with a school district where, for instance, their incident logs, okay? They use a proprietary format that the only way you can read a file that's generated from the software is if you have a copy of that software itself. And they cannot generate like an ASCII file or a CSV file or anything like that. The software simply doesn't do that. I haven't seen this come up in a while, but when it did, we ruled that since the agency could not generate the report, they got a pass. Okay, they weren't required to go out and like develop some conversion patch that would allow them to. They didn't have to incur any additional cost. Okay, most proprietary programs that are used by police departments nowadays can generate non-proprietary reports. So it hasn't been an issue, but a couple years back it was. Just something you should be aware of in case you ever run across it, okay? Okay, I talked about, for proprietary formats, could you argue screenshot program to generate the report? That issue was brought up and it didn't allow generating a screenshot in such a way that you could get the entire report in a readable, picture. Okay, it just didn't work out, and it wasn't. There were conflicts between the operating system that takes the screenshot and the proprietary software. It just didn't work out. But nowadays it's hard to say. In all honesty, that issue has not come up for several years. It might be something I should probably remove from the presentation. But it was an issue a couple of years ago. That's why we still keep it in. But that's kind of what was going on there. If we only have it in PDF because it was from years ago and they request Excel, can we get in trouble? No. The bottom line is, what do you have in your possession? Okay, and if you only have a hard copy record in PDF format, then that's all you're obligated to produce, okay? If you had to go back and reproduce it in Excel, that would be creating a record in general terms, and under the right to know law, you do not have to create a record. So if all you have is PDF, I think you're responding in good faith to what the requester is asking for. Okay, and to answer your question, bottom line is, no, I do not think you would get in trouble. All right, let's talk about redactions. Remember I said you cannot charge a redaction fee. However, there may be instances where you can assess a charge for having to do a redaction. And let's talk about that. Let me get a sip of coffee here quick. Okay, so what is a redaction? Well, this is where the agency's decided this is a public record, we're going to release it, but there's some sensitive piece of data on the record that we don't want to include with the public record itself, so we black it out. Very common ones would be like a social security number, home phone number, personal email, something like that. So there's two ways that you would redact. The first is, let's say you have the Adobe Office Suite, which has redaction software included in it. So you're able to bring it up in Adobe, and then you can electronically and securely wipe out that piece of data and then return it to whatever program and send it off as a responsive record with the redaction. The second way is, let's say you don't have redaction software. So you take the electronic record, you print it out, and then you take your Sharpie or whiteout or whatever, cover up the sensitive data element, and then scan it back in and send it off to the requester in the redacted electronic format. In that particular scenario, you can charge for the paper that you had to generate to affect the redacted public record. Okay, that's up to that 25 cents per page. You see how that works. Now, if you have, this is the position of our office right now, okay, this may change if we continue to get appeals and let's say they get escalated up to higher level court. If you have redaction software, the position of the Office of Open Records is you should use it. Not you shall use it, but you should use it, okay? And we have no enforcement authority relative to this. We're simply saying, look, you know, if you can generate the redacted public record without assessing a charge, that's what you should do. But there's nothing in the law or case law at this point that says this is what you must do. All right. Also, inspections. All right. Some agencies don't run across requests for inspections very much, but you should be aware that under the right to know law, a requester can request copies of records or they can request to inspect the records. And if you've determined that the records they want to inspect are in fact public, but again, there's some sensitive data element, you can make a copy and then redact that sensitive data element for them to inspect. Now with these fees, like everyone expects the inspection to be free, but now you've created a redacted copy and you can charge them for that. You can charge the up to 25 cents a page. But what you should do, two things. Number one, call them ahead of time and let them know that there would be a fee and ask if they're willing to pay that given the circumstances. Because again, they may back off. They may say, no, I'm not going to pay just to look at some records. So then the request is withdrawn. The other thing is that if they agree to pay, then when they come in to inspect the record and you've made a redacted copy, give them that copy, okay? Because that's what they're paying for. It's theirs now because they paid for it. So they should be able to leave with that redacted copy, all right? But you see how this all works. Now at the end here, I think this is an interesting point that you need to keep in mind. A redaction officially, and officially in quotes, is a denial. You're basically saying you cannot see this specific, whatever's underneath this redaction, okay? We've determined this is a public record, but, okay? And usually in your response, when you're granting, and you know, forgive me if there's anybody here that's on the requester side. I'm talking, you know, essentially from the agency side, because most of the people are from an agency. But you can kind of see, you know, how you fit in here. If the agency redacts something, when you do the grant letter saying we're giving you this record, but we've redacted something, you should tell them what's behind the redaction in general terms, okay? Because there is a Social Security number, and the IRS has determined that, Social Security Administration has determined that Social Security numbers are confidential, okay? So that way the person can make that judgment as to whether or not they feel the Social Security number should be a public record or not, okay? Because they can appeal redactions, because in essence, they are denials, okay? So questions are popping up here. If we make a redaction, let's say 2 pages, 50 cents, someone else asks for that. Well, would we charge both 50 cents or just one? Okay, well, remember, the redaction, okay, I see what you're saying. So it's electronic at this point. You charge for one, but now you have the electronic version on file with the redaction. The answer is no. Only the person who filed the request that resulted in the hard copy redaction would pay. Because you now have the redacted version in electronic format in your possession, you would not pay for a copy of that redacted record. Okay, that's an interesting question. That's never come up before. Okay, now what happens if you have a hard copy that requires redaction? Okay, I'm not required to scan the hard copy. Should I redact with whiteout, scan the redacted copy, and charge for copying? Okay, I'm not sure I understand. You have a hard copy, no electronic then. Okay, you have redaction software. Okay, here's the thing. If you have redaction software, you should use it, but you're not legally required to use it yet. Okay, that may change. So you have a choice. You can use the redaction software and not charge, or you can print it out, do the manual redaction, scan it back in, and then you can charge for the redacted copy because you had to use paper. And you mentioned whiteout. I'm told whiteout works better than Sharpies because it's more opaque. Okay, sometimes when you use a Sharpie, all you need to do then is hold the copy up to the light and you can see whatever you scribbled over. Okay, hopefully that answers your question, Julia. Yeah, okay. All right, moving on. Waiting for the screen to change. It's not. Oh, there we go. Okay, I hope I didn't go too far. Okay, charging fees. How do you do that? Well, let's run through a scenario here. Someone submits a right to know request. Oh, it did advance. Let me go back. It'll take a second. So someone submits a right to know request. The first thing I recommend is that the agency do a quick estimate. Okay, you're asking for this report, these pages, so forth. It looks like it's going to be around $30. So send an email or pick up the phone, call the requester, say, hey, I did a quick estimate. I think this is going to cost about $30. Is that okay? Do you still want us to process it? Okay, there's a lot of people who misunderstandingly think that the right to know law is free, and we know it's not. Okay, so they're either going to back off or they're going to say, yeah, that sounds reasonable, go ahead and process it. All right, then the second thing you want to do is take a look, what if the response is going to exceed $100? Okay, if that's the case, there's what I call a security deposit clause in the right to know law under section 1307, where the agency at its discretion can say, this response is going to cost in excess of $100. Send us a check for the entire amount, and we will hold that so that we don't get stiffed for generating all these copies and then you back out and balk at paying. Okay, and it's just exactly as I described it. It's so that the agency doesn't get left holding the bag for all these costs and then the person backs out. They have the check on hand and they can even process the check if they want to. And then you settle up on the exact amount once all the copies are generated and turned over to the requester. Okay. Now, here is a very important point that I want to make sure everybody understands, both agencies and requesters. All of the deadlines built into the right to know law refer to the date of the response, not the date that the agency is required to provide the records. You've got the 5 business days. You've got the 30 calendar days. If you look at the law, the word is response, not records. So an agency can respond within the 5 business days and say, we are granting your request. We're going to give you the records. And then they can turn around and say, as soon as you send us a check for the full amount and it clears the bank. And that might take more than 5 business days, or it might take more than the 30 calendar days. As long as the agency, once the check is cleared, provides the record in a reasonable period of time. Okay, now that's a very subjective term there, but usually, you figure it's going to be a couple days, at most maybe a week to get the records out once the payment has processed and the check is clear. Okay, the way the law reads is that the agency provides the records upon payment, which means the requester pays first, then they get the records. Now, not every agency does that. Some agencies will send the records out along with a bill and say, send us a check. Okay, sometimes they get the check, sometimes they don't. All right, there's nothing in the right to know law that prescribes how an agency goes about collecting fees. It simply says records are provided upon payment. So you can demand payment, wait for the check to clear, and then provide the records. What the law does say is that you must provide the response, whether it's a grant or denial within the 5 business days, or you take the extension and you provide the response within the 30 calendar days. Okay. Hopefully that makes sense to you, and it provides some clarity on how all that works. Okay. I think we have pretty much covered this slide. Let me advance again. Don't know why there's this delay with this system, but okay, clock is ticking. I feel like we should have the Jeopardy music taking place here while we're waiting for the slide to advance. There we go. Okay, record discard. Okay, so here's the scenario. Someone has submitted a request that for hard copy records, and they've said, okay, and the agency has agreed to this. We're granting your request. We'll have the copies ready for you, and you can pay for them then. Just come down to the Borough Hall, the Township Building, or whatever, the School District Administration Building, and you can pay for the records at that time. Well, let's say the person doesn't show up right away, and the agency's holding all these records. Well, under this section, 905 of the Right to Know law, you have to hold the records for 60 calendar days, 2 months. All right. If the person does not show up after the 60 calendar days, the agency can then dispose of the records. Okay, you can shred them up, you can recycle, you can do whatever. All right, but here's the thing. There was a cost associated with those records. The requester still owes the money, even though those records have been destroyed. Okay, the agency did everything it was legally required to do. They incurred a cost. It's not their fault that the person can't show up in 2 months to pick them up. The cost does not go away. Okay, the requester still owes them. And as long as there are outstanding fees, the agency is not bound to process any further right to know requests from that same requester. All right, you got that? If there are any outstanding fees, the agency can deny any further right to know requests until all debts are settled up. Now, if you deny a subsequent right to know request because of outstanding fees, that is a denial and the person can appeal that. But if the agency has dotted all its I's and crossed all its T's, meaning you've documented all of the communication, you've documented how you calculated the fees that are outstanding, et cetera, the appeals officer will usually rule in favor of the agency. And like I said, you can search our database and bring up all the decisions related to fees and see the thought processes that were used by the appeals officers. Usually it's in excess of 90% where the appeals officers agree with the agencies, provided the agency has done its due diligence. If you're a little sloppy with your paperwork, if you're kind of shooting from the hip, if you can't meet your legal obligation, your burden of proof, just like any other appeal, then the appeals officer is going to ding you. But if you're doing it right, you'll be okay, right? And then, like I said, there's nothing in the right to know law that addresses collection activities. So if there is an outstanding debt, how the agency goes about attempting to collect that outstanding debt, that's up to the agency. All right, questions come up. When you shred records that were never picked up, is there a best practice associated with any procedures? Okay, should we put a note in the file? Yeah, I would recommend having something memorializing what happened related to that, because under the right to know law, you're required to keep records of all requests and the transactions that took place. So if records were destroyed as a result of them not being picked up within this section 905, you would want to have a note in the file to that effect, okay? Because if it ever does come back through an appeal, that would kind of close the loop by having that note in here that the records were disposed of. In some instances, the agency will still hold on to them, but they have like a records disposition date. They'll say, well, just because this is right to know, per our retention schedule, we're going to hold on to everything for 2 years, but after 2 years, we're going to dispose of the files. Okay. Well, after 2 years, the appeal window has long since closed anyway. So they'll dispose of them after 2 years per the retention schedule, and that's the end of the story. But yeah, Julia, I would suggest doing that. Have something in the file saying that, yeah, the records were disposed of because the requester never picked them up. Okay, do we follow the regular denial process if a requester owes an outstanding balance? Yes, you would issue a denial saying that you still owe us money as a result of this previous right to know request, and you may have like a request number or something like that, or the date that it was submitted on, and say that until that debt is settled, we are denying any further requests from you. And then you put in their appeal rights, because if you believe that, our position on this is incorrect, you can appeal it to the Office of Open Records, et cetera, et cetera. Okay. You would handle it just like another appeal. Do they need to resubmit any requests that are denied for this reason? Well, they can resubmit the requests, but again, until the debt is settled, for that previous outstanding request, you can deny any subsequent right to know request, whether it's for the same set of records or a different set of records, okay, until the debt is settled up. And there's no statute of limitations on this. It doesn't go away after a year. It doesn't go away after 5 years, okay? If they owe you money and you have it documented, it can go, you can deny that subsequent right to know request. Okay, now let me go off script a little bit here and talk about what we call, diplomatically, problem requesters. Occasionally, the greater majority of people who are requesting public records through the right to know process have a legitimate reason for wanting these records. Okay, they've got a problem. You're going to help them solve it by giving them the public records. But there are a handful of people out there, for whatever reason, the relationship between the agency and the requester has broken down. Maybe they don't like the person who got elected to council last month or last year. Maybe they got a parking ticket that they disagree with. Maybe they got cited for a code violation, something like that. Maybe they got voted out of office, okay? And now they've decided they're going to be a pain in the neck. And one of the ways they're going to be a pain in the neck is through the right to know process, by filing a lot of, what you might call frivolous right to know requests. Under the right to know law, you cannot deny a request based on the reason or what you think the reason might be, okay? But then you still got this problem. Well, my experience, having been the right to know officer for the Office of Open Records, has been if you have a problem requester, the solution to dealing with them is on the payment side of the right to know law. People will pay nominal fees for legitimate requests. People will not pay to be a pain in the neck, okay? If you have a problem requester, if you can figure out a way, or if you realize that we should be charging for these records, they're going to go away, okay? And you understand what I'm saying here? If I have a legitimate need for public records, 25 cents a page is a bargain, okay? But if I'm just submitting right to know requests to be a pain in the neck, I'm not going to pay for that, okay? Because I'm just that type of person. And 9 times out of 10, if you can figure out a way to assess a fee for the requests that are submitted by these problem requesters, they're going to go away. And a lot of times you would be surprised at what you can charge for if you are dealing with this from an above board way. But if you're only charging the problem requester and no one else, is a violation of the law correct? I'm not sure how you would be violating the law, okay? If there are fees that you should be charging, and you should be doing that across the board, whether it's a legitimate requester or a problem requester, why would you differ from one to the other? Okay, now, I will backpedal on that a little bit, because here at the Office of Open Records, at least during my tenure, occasionally we would have inmates who were problem requesters. And the quickest way to make an inmate go away is to send them a bill. Okay, but most inmates, they were requesting legitimate records, so we would send them to them for free. Because typically at the Office of Open Records, we don't charge for right to know responses because it's just easier. Everything's electronic in the first place, and if we have to scan it, it's just cheaper to scan it in and send it to them for free than it is to send them an invoice. But occasionally we would get an inmate that would, request all these crazy type of records. If you send them a bill, you never hear from them again, okay? So it's not a violation, all right? If that's the practice that you take. But the question that I think we should ask in the first place is maybe we should be charging everyone for the same processes and types of records that we're sending out. That's at the agency's discretion. So an agency can choose who to charge and not to charge based on who they want to provide the records to. That's why I'm saying maybe you should be charging everyone. All right, it's an agency decision. What I am saying, though, is that if you have a problem requester, maybe you want to take a look at what you are charging and not charging for. And there's a chance that if you can assess a fee like that redaction charge, that the problem requester will go away. All right, and then Hopewell is saying we have a problem requester willing to pay. Yeah, there's always one. Is there anything else we can do? Well, you want to take a look at what are they asking for? Are they truly public records? If they're willing to pay, then that kind of shuts down that option, okay? Just make sure that they're paying for everything that they should pay for, that you are in fact billing them for everything that you can potentially bill them for. A problem requester who's willing to pay is a rare bird, okay? That's, what I'll say. I don't really have another solution for that, but, there's nothing preventing you from maybe calling the office and talking to an executive here or one of the attorneys and seeing if maybe there is, a possibility that there's something you can do, but it doesn't sound like, well, I think it's going to depend on the specific situation. I don't have another answer for you at this point. And yeah, okay. All right, so let's move on here. Another sip of coffee. Still waiting for this slide to advance. Here we go. Okay, question has popped up in the meantime. Our problem requester has resubmitted the request as a demand for records and is refusing to pay the fee. The request is over 900 pages, so it is costly. How would an appeal be handled for a demand for records? Okay, well, I don't know what that is. Okay, if it's part of, a subpoena, if it is truly a subpoena, that's something different and is dealt with outside of the right to know law. But a demand for records, I don't know what that is. If you can interpret it as a right to know request, and under the right to know, you pay, okay, per the fee schedule. So just because he's using a different, or she is using a different term, a right to know request is still a right to know request. And the open records law is what determines the appropriate process. I mean, you can go to the preamble of the law. The purpose of the right to know law is to give the public access to public records. And there's nothing in the right to know law that says, unless it's a demand for records. It doesn't recognize that term. So I would treat it just as if it is a right to know request, and they can seek whatever legal remedy they feel is appropriate. But if they appeal it through the right to know law, the first step that takes place is filing a right to know request. And if they cannot provide a copy of the right to know request, I'd say they have a problem, okay? Because you don't appeal demand for records requests to the Office of Open Records. We only deal with right to know requests. Okay, so I would say first, there's no such thing. Second, you've chosen the inappropriate venue. And I don't want to get into the legalese because I'm not an attorney, but this is just based on stuff I've seen. It sounds like this might be, well, I don't even want to go there. I've already addressed this too much. I don't know what a demand for records is. A right to know request is a right to know request, no matter what you call it. All right. Sidebar, no surprises. You've kind of sensed me hinting at this, and it comes down to communication. Communication within the right to know law process can save you a lot of work and a lot of misunderstanding. There is nothing in the right to know law that prevents people from talking to each other. Okay, like I said, if you get a right to know request and you don't really understand it, pick up the phone or send an email back to the requester saying, hey, do you mind explaining exactly what you're asking for here? Because, I'm missing something. Can you help me out? Or, like I said about the costs, okay? We think this is going to cost you $30. Are you okay with paying that? Can we assume that, we're going to get payment and you want to proceed with this further, or do you want to withdraw your request? The other thing is that a requester can put on their request a cost limit. They can say, look, if the response is going to cost more than $10, call me, okay, contact me. But if it's less than $10, go ahead and process it. I don't have a problem with that. That is perfectly fine, all right? Okay, talk to each other. It will lessen any misunderstandings, and that will make your lives easier in the long run. Okay, now remember when I said you cannot deny a request based on the reason. The law does not say you cannot ask what the reason is. And occasionally, let me get into this a little bit. I realize we're up against the hour, but I'm here all morning. Here's the scenario. You get a right to know request, and from the requester's perspective, they've got a problem, okay? It's going to be solved by getting a public record. I don't know exactly which public record it is. I just know that the township has it, okay? And let's say they're attempting to file their taxes, and the IRS has said, in order to claim this deduction, you need documentation from the township that, in fact, this took place, okay? Yeah, let's just say that's the scenario. So you file a right to know request with the township, and because you don't know the exact record, you cast a broad net, okay? So the township gets this right to know request, and it's like, this, I'm really not sure what this person is asking for, and given the way they worded their request, this could be a really big response. It could take a lot of time, could cost a lot of money. So pick up the phone and call the requester. Say, look, I don't know if you realize how big a request this is. Do you mind telling me why you're submitting this request? And it could save me a lot of time and it could save you a lot of money. Okay, well, right there, you've got their attention because you're going to save them money. So then they say, well, yeah, I've got this tax issue with the IRS. They say I need this form from the township to solve my problem. And suddenly you say, oh yeah, we deal with those all the time. I know exactly what they're looking for. I can have that ready for you this afternoon. Okay, now that's, somewhat of an exaggerated example, but you see how it works. You're working together. You can ask the reason if it appears it's going to solve a problem for you. Okay, so communication is good. All right, moving on, and I think we're getting close to the end here. Waiting for the slide to advance. Come on, come on. Yeah, certified records, real quick. There's a provision, 1307C of the Right to Know law, that allows agencies to generate certifications and charge $5 for those certifications. The certification is nothing more than a statement that says the records we are providing, or the copies we are providing, are true and correct replicas of the originals. Okay, they haven't been altered in any way. You are not certifying the provenance of the records themselves, the content of what's contained within the record. Okay, similar to like how a police department might certify a chain of evidence. Okay, you're simply saying, here are the copies. They are true and correct representations of the originals, and then you can charge $5 for that certification. Okay, and if you need example language, go to the website, go to the Arrow guidebook, and you'll find sample language in there that you can use for the certification. Next, we're going to talk about transcripts. This is going to take just a minute. Okay, sometimes there will be an adjudicatory hearing that a local agency may conduct, and they have a transcriptionist come in, a stenographer, to make a verbatim transcript of the hearing. And then someone submits a right to know request for a copy of the transcript. In order for that to be provided through the right to know law, there is a two-part test that needs to be met for it to be deemed a public record that is provided. The first part is that all appeals need to have been exhausted for this adjudicatory process. Maybe the township ruled their county court of common pleas, maybe then it goes up to the Pennsylvania Commonwealth Court, maybe then it goes up to the Pennsylvania Supreme Court. Depending on what's the highest level of appeal, and that those appeals have been exhausted, only if they have been exhausted, then have you met the first part of the test. Okay, all appeals must be exhausted. Then you come up to the second part of the test, and that is that the agency, whether it be township, school district, city, borough, whatever, must have the transcript in its possession. And that can be interesting because many times an agency will pay the transcriptionist the hourly rate for showing up and taking the actual transcription, but they do not pay for a copy of the transcript itself. That's maintained by the transcriptionist, and they will only pay for it if they need it as the result of an appeal, because there's usually a per page charge, and that per page charge is much greater than the 25% per page fee that's allowed under the right to know law. Now, if the agency does have a copy of the transcript and all appeals have been exhausted, Then you can respond to it as if it's a public record, and you only charge up to 25 cents per page. Now, the transcriptionist might say, whoa, wait a minute, that's my product, and I charge $2 a page. So you owe me the $2. No, if the agency has already paid the $2 and they have it in their possession, then it's a public record and you would charge for it just like you would any other public record. Now, if the agency doesn't have it in its possession, then they can deny the right to know request, and the only recourse the requester has is to go to the transcriptionist and pay whatever fee they charge, because at that point it's outside of the right to know law. Okay, but that's how all that works. Comes up every now and then. Okay, and that brings us to the end of the right to know and payment issues presentation. If you have any more questions, now's the time to get them in. It's the same true for plans for subdivisions for new homes. Katie, no, it's not. Plans, okay, there's a difference. If it's a subdivision, that may or may not be a public record, and it would not be, chances are it's a public record, and you would make a large-scale copier and charge accordingly, okay? Very rarely can I think of any reason why a blueprint for a subdivision would not be a public record, okay? Now, if you're talking about plans for the home itself, that comes under the Uniform Construction Code, which is Pennsylvania's building code, and that would be considered confidential under the UCC, and you would withhold. I mean, think about it. Why would you give out the plan for someone's private residence? Okay. You raise a good issue, Katie, in that we discussed this in a webinar called Laws That Make Records Confidential, or I think, other confidentiality laws, I think is what we call it, or laws that make records private. I forget the actual name of it, but we discussed the UCC in greater detail. But yeah, subdivision plans themselves would probably be public. Home plans would not be. Okay. Hey, folks, if you're new to the world of open records, I want to bring your attention to our website. It is the best government website you will ever encounter. It's updated 6 days a week with new information. On there, you'll find a citizen's guide, an agency guide. I mentioned the database for final determinations. There's over 30,000 decisions on there that you can research in a searchable database. Thanks, Walt. I was having a senior moment. Laws that protect information. March 13th. Okay, coming up soon. I'll be there. You're going to find all kinds of information on this website that will help you out. Your training events, okay, these webinars, all the information about webinars is on there. If you're a real geek about government transparency, subscribe to our Twitter feed, okay? You're going to find every morning at 8 a.m., we will wake you up with a tweet of all that day's information on government transparency. And then finally, if you still have questions, reach out to our office, go to our website. There's email accounts that you can use. You can call the office itself, speak to one of our admins, and we'll try and get you headed in the right direction. We cannot write right to know requests for you. We cannot respond to right to know requests for you. We can't discuss active appeals, but chances are, with 30,000 appeals and counting, whatever you're dealing with, we've already dealt with, okay? And we can kind of steer you towards those decisions and get you moving in the right direction, and we'll help you out as best we can, all right? So I want to thank you for your time here today. Thank you for helping me deal with the technical issues at the beginning. We've got this brand new system that, it looks pretty slick, and once you get it up and running, but for whatever reason, we used to have a computer here in the room, and now I have to bring in my laptop, and for whatever reason, my laptop was not connecting to the network. which in turn connects to this new system. And so we're actually using someone's iPhone to connect to the network that is then Bluetoothing to my laptop, and it works, okay? But, you know, we shouldn't have to do this. So we're going to try and sort it out here later today. But thanks everyone for your patience for these last 2 webinars that we've done. We're slowly figuring it out, and we'll get it sorted out. Yeah, that's why we have the delays too. Usually when I hit the button to advance a slide, it's instantaneous, and now it's taking like 5 or 10 seconds. So we'll sort it out. But again, thanks, and hopefully we'll see you in 2 weeks when we do our next webinar. Have a good one, folks. Stay safe, and we'll see you on the flip side.